opposition at the Committee of Assessment, but we see this
Yeah, Madam Chair, typically the situations that have been brought up when there's an extra unit that the other Councillor Nussbaum's mentioned is roughed in. Typically, when you see it in a building code, like on the plans, it would say something like storage or computer room, where it's identified as something else. And to get the building permit to do that, to be in conformity with the zoning bylaw, that's a way of sort of around saying it's going to end up being a fourth unit, because if in this case they would have to come and do a rezoning and go through the process of determining if that land use was appropriate. But in the
last meeting,
Councillor.
Brockington?
Process question first. We don't have anything before us now about OMB that my colleague was mentioning. We have a two-parter that's asking us to approve this. If we choose not to approve it, what happens?
Madam Chair, I would imagine that if you choose not to approve it, it would go to council, and depending what council did, if they chose not to approve it, it would go off to the Ontario Municipal Board, where at the board they would look at the merits of whether or not an apartment building was a low-rise apartment building was an appropriate use for that site. Now, obviously, the process or the procedure has resulted in these questions and the discomfort and concern that are raised by the councillor. But at the board, there's no consideration for the process it took to get there. There's no style points for it. There's just whether or not that use is the appropriate use. So that would be the question before the board.
But it would only get there if the applicant decided to go that route. It's not automatic.
Yes, Madam Chair.
Okay, so is this item before us because that fourth unit is being considered? If there wasn't a fourth unit, we would not be here at Planning Committee.
Yes, Madam Chair.
Okay, so is Mr. Chown going to speak?
He will if he can, if he wants
All right,
to.
Then
but he's here for questions as well. But you know, the questions you're asking are good, fair questions. But in the staff report, it does say that had they gone from the beginning and asked for 4 units in each of these, that they would have had the same support for it from the very first. Well. So this is, if I'm not speaking for Councillor Leeper, but I am saying what you see. I can. Councillor Nussbaum's getting ready to do something. I can tell. You're unhappy with what you see as backyard kind of like dealings, is what you're saying. Yeah.
Absolutely, it is seen time and time again. The built form itself is not the subject of opposition here. Building the triplex and then putting in the fourth units, I think most residents of Kitchissippi would recognize that is the kind of built form that is going in. The zoning would contemplate this kind of a built form, but time and time again, we're seeing it done after the fact, and that is hurting residents' trust in the planning process at the City of Ottawa. And you know, it's obviously I've seen numbers, and we're going to take a look at numbers at the next Planning Committee meeting that show the number of variances that are being requested in Kitchissippi are equivalent to the number of variances that are being requested for the next 4 urban wards combined. It's transforming our streets. People are trying to come to grips with it in the ward, but it translates into things like resentment against LRT, because LRT is driving this kind of intensification. There are conversations that could be much more productive if people had planning processes like what we're seeing today damage and ultimately destroy that trust.
But what we have before us today, and Mr. Mark is here to verify, is a new application for 2 units at each of these locations. It's a new application, and we are, as a planning committee, it's not within the provincial planning documents, if you will, to make a decision that isn't from a planning perspective. So this is a new application. I think you were clear in the report in saying that too. This is a different application. So I'll go to Mr. Chown. Did you want to say anything?
Certainly do. So, Madam Chair, if I may, I think there's 2 very distinct conversations to be had this morning. The first is on the merits of the application and the report that's before you that's recommending approval of the rezoning from R3 to R4, which would allow for the addition of 1 unit in each of the existing triplex buildings. And I think staff have written a very succinct report explaining why they believe that you should recommend approval of this zoning application to council. If I may use this phrase, and I'm going to use it over and over again in the coming months and coming years, I think that what is before you today is probably the most discreet form of intensification that Planning Committee and Council can deal with and hopefully approve, where we're adding 1 or 2 units in an existing building or in a zone which otherwise allows for maybe 3 units, and we're now going to have 4 in a very desirable location on the edge of a community where this form of housing will provide a buffer between collector streets or arterial streets, whether it's Byron Avenue or Richmond Road or Carling Avenue or any of the other major roads in this city, where this form of development will provide a separation between those streets and the stable interior neighborhoods. Certainly, there's no change in terms of what you see on the street between what's there today and what will be there tomorrow if Planning Committee and Council approve this rezoning. So I'd certainly encourage you to support staff and the recommendation that's before you today. The second conversation is, how did we get here, and why are we hearing this huge outcry from the community associations, neighbors, and councillors about the process? With all due respect, there's a very simple explanation for why this is happening. Most of the builders who are building these duplexes and triplexes are small builders who do 2 or 3 projects a year. And so they don't have the luxury of being able to carry properties for extended periods of time. They need to get in, build something, and get a revenue stream coming out of that building. The difference between a 3-unit building and a 4-unit building is very significant in terms of the costs and the time associated with getting those approvals. There's 2 scenarios. One is if you're already in an R4 zone where a low-rise apartment building is permitted, or that 4-unit building is permitted. And so there the situation is, to build that 4-unit building, you need a site plan approval and possibly minor variances. That site plan approval is time-consuming and expensive. And the the minor variance process is unpredictable. So what are builders doing? They're coming in, they're getting their building permits for their 3-unit dwelling, they're getting that building up, generating rent, and then making the applications for site plan approval and, if necessary, minor variance. The situation we're in here today is different because we're in an R3 zone, which doesn't allow that 4-unit building. So what's required for the 4-unit building, once again, is site plan, which is time-consuming and expensive, rezoning, which is time-consuming and expensive, and unpredictable. So what does the builder do? The builder goes out, gets his building permit for his 3-unit dwelling, constructs that dwelling, gets a revenue stream going, and then comes back with the applications with no guarantee that he's going to get approval of his rezoning or, in the R4 example, approval of the minor variance. So that's why it's happening. It's happening because these small builders need to get going. They can't afford the carrying costs associated with the site plan, the delays and costs of site plan approval, and in this case, zoning. So they build first, get some revenue, and then take their chances coming back later for permission for that 4th unit. Now, having said that, I go back to the first discussion. I believe quite confidently and strongly that this is a natural location and a desirable location to allow for this form of housing. I think you need to bear in mind what this block on Byron looks like. Immediately to the west, there are 3 legal, non-conforming, low-rise apartment buildings that have 6 or 12 units in them. What is being proposed here finishes off the block. It makes good sense. It's a good planning decision. I would encourage the committee to accept the staff recommendation and recommend approval of the rezoning to council. I'm happy to answer questions.
And you have at least one from Councillor Leeper.
So, Mr. Chown, you suggested there are 2 things that I think I'm catching in what you've just proposed to the committee. The first of which is you are saying that they intend from the beginning to have those 4th units in there, that those are going to be dwelling units.
There's a desire to have that 4th unit.
And yet they're labeled.
But there's no expectation that they're going to get it.
So, and I'm not sure, I didn't take a look at the site plan on this one, but I assume it was labeled as something other than future residential unit. It was probably labeled with something to Mr. James's point, storage, computer area.
I believe it was shown as storage in this case, but I too have not looked at the drawings because, with all due respect, what's happening inside that building is of no interest to me. What's of interest to me is what is the planning merits of the application. So I have not set foot inside the building.
So the builder wants to build a 4th unit. There is that quote-unquote desire that you just noted, but they label it something else.
They have to do that for building permit purposes.
Right. So I think you can begin to understand the residents' mistrust in the system. And then the second point, and it's not necessarily a question of you, but I'm interested in hearing your thoughts on it. What you're suggesting is that we need to enable small builders who can't afford to build 4plexes instead of triplexes. We need to enable them. And I think that you've probably, and you and I have had a number of discussions already about what happens when you enable very small builders in neighborhoods like Kitchissippi, where the largest builders don't create a lot of problems with neighbors. But you know the process, and I think we're talking about it this week, about some of the construction practices that very small builders often engage in. I'm just not certain that we should be bending over backwards to take it on face value that somebody is going to build storage when they intend to build a 4th unit in order to enable a developer who can't afford to build one more unit in that building. I think what we're asking for is a recipe. It is a recipe for those small builders who are creating so much havoc with respect to construction practices in our ward. Again, it may not be in the Planning Act, to the chair's point, that we can reject this on the basis of anything but the built form, but we need to start getting a handle on this.
Madam Chair, I'd be more than happy to sit down with Councillor Leeper and have this conversation offline, and I look forward to that opportunity.
Because I'd like to stick to, and thank you so much for trying your best to make sure that the record was not beaten today with the questions and stuff. I think we're off track now too. Isn't that more of a? I know that it's what is concerning you about this application, but if we deal just with the application before us today, and not the past history, which is what we're supposed to be doing. I know that you're the counselor for the area. I think we all get that. Sure.
Thank you, Chair. No, I do think it's useful to have Mr. Chown here just to understand a little bit what's happening in the minds of builders of these situations. So in this case, Mr. Chown, there was a committee of adjustment application. So although you're not the builder, I'm just curious if you can give us your best guess as to, while I understand the bit about needing the rent stream earlier rather than later, in this case, what they've ended up with is two separate processes. So they had to hire you, and they had to get, they had to come in with a zoning application, and then separately they had to go to committee of adjustment. So presumably, if they had done that as one exercise instead of two, one would think that that would be cheaper and faster and easier to do that as a one-shot as opposed to a two-shot deal. So understanding everything you said, and I think that's helpful for us to understand what the systemic challenges are, why in this case, if you were in the minds of the applicant, why not seek the zoning amendment at once, and then you can get the minor variances as part of the zoning amendment, and then you don't need to go to committee of adjustment?
A good question. Firstly, for the record, I wasn't acting for this client at the time. He went to the Committee of Adjustment. He only came to me when he was considering the rezoning application. But the difference in this case isn't so much the minor variance versus the rezoning. It's the minor variance allowed him to build the triplex. And the minor variance process is less time-consuming and less expensive than rezoning. And the real trigger, the fourth unit also triggers site plan. So by just doing the minor variance first, he postponed the time and expense of both site plan and rezoning. And I assume that's the reason he did it in two steps. I wasn't part of that discussion initially.
Okay, thank you.
Anyone have any more questions for Mr. Chown? No? Thank you. Thanks for coming out today. Councillor Hubley, question for Ms. Nutt?
For Ms. Nutt, if I could, for staff. Are we doing anything like I hear what Mr. Chow was saying about the why they're making the choice to do it this way is because of how expensive and time-consuming being honest and forthright with us up front would cause them. Are we doing anything to try to level that playing field there so that they don't have to make that choice?
Madam Chair, we are in the currently looking at our site plan control review process, so we are examining different thresholds going forward. So we will be coming back to committee likely in the beginning of the new year to talk about some changes that we do want to make in terms of change to allow for certainly to be more efficient with our site plan review process, to be more cost effective with that process, and to allow those types of developments to move forward in a more faster fashion coming that we want to see happening and taking place. So we will be back to committee to share some of our results of that review.
Okay, thank you. Madam Chair, I'm seeing this. I listened to Councillor Leeper. I think you made a good case suggesting that this was wrong, that they're taking advantage of the process. But the more I heard about this, it seemed like we, as the city, are putting them in this position that they have to do this. So I'm happy to hear that you're going to make some changes with it. I'm going to say sorry to my colleague, I can't support you, because if staff are going to support this application anyway, really you're just asking us to waste tax dollars by sending this to the OMB to get approved very quickly at OMB because staff support it. So I hear you. I think if we have one, if this is going on a lot in your area, and if we have something that we have a good case to hold them and make changes to it, then I fully support you, but I can't support something that we know already what the outcome is going to be. Okay? Thank you, Madam Chair.
Okay, thank you. If no one else wants to speak, Councillor Leeper has asked for yeas and nays. On zoning bylaw amendment 266 and 270 Byron Avenue, Councillor Blais, Councillor Brockington.
Yes.
Councillor Shirelli? Yes. Councillor Puche?
Yes.
Councillor Hubley?
Yes.
Councillor Leeper? No. Councillor Nussbaum?
Yes.
Councillor Kadri?
Yes.
Vice Chair Tierney? Yes. And myself, yes. It's 8-1. Close. Anyway, thank you, everybody. So we have, I'm going to ask that you waive the rules. Vice Chair Tierney?
Yes, Madam Chair, thank you. Whereas 1534524 Ontario Inc. and Finley Creek Properties South Limited have submitted the 4M plan, financial securities, and signed an agreement for the registration of the planned subdivision. Therefore, be resolved pursuant to the rules of procedure, subsection 89.3. The following motion be added to the agenda of the Planning Committee on today's date, October 10th, 2017.
So this is about the email that I sent you, I think later on Friday. And this is resulting from the OMB ruling with regard to who pays for intersections. And so we have a tartan application in Finley Creek area that is waiting for approval of the subdivision. It requires this. Mr. Mark, did you want to make any comments on it?
Yes, Madam Chair. This intersection, or this subdivision, has an intersection that, pursuant to the board's decision of November 29th of last year, is now to be funded through development charges. There are, of course, by the time this decision came out, the 2017 budget had been dealt with, and there are not funds allocated in the 2018 budget for this intersection. I understand that funds can be made available in 2019. Committee may recall that the bylaw was amended, I believe it was in May of this year, that will increase the development charges gathered for this purpose, and thus funds will be available in 2019. This subdivision is ready for registration now. Staff do not have authority to approve a subdivision for registration unless any monies that will be required of the city have been approved by council. This motion will allow funding in 2019 and thereby allow this subdivision to be registered.
Okay. So on waiving the rules, and that was included in the motion, so and on the motion, carried? Thank you. Any notices of motion?
Madam Chair?
We have the other one? Oh, yeah, it has to move. Yeah. Yeah, yeah.
So on that, be it resolved to expedite the completion of the roadway modifications agreement in a timely manner. Planning Committee recommend Council suspend the notice requirement under Section 29, 3, and 34. 1 of the procedure bylaw to consider this report in the meeting of the 11th of October 2017. Is that correct?
Carried? Thank you. Any notices of motion? Any inquiries? Other business? Other businesses. This is going to be over at 10 o'clock this morning. The next one is not going to be the same. Just saying, be prepared with your schedules. Yeah. But it's quite a large agenda. The next meeting? Well, there's just a lot of items, which may or may not be contentious, which may or may not have people coming out for them, but there'll be, but it's a lot of items. And so we're adjourned until the next meeting, October 24th. Thank you, everyone.